Thank you for being here. Today, we're delighted to have Zach Harned from Fenwick West to give our presentation, and delighted to have him here. He was part of the launch of our Legal Office Hours program some time ago now, which is a nice program for our Stanford community faculty, staff, and students to get a complimentary 30-minute legal consultation related to corporate or IP issues. As I said, Zach works for Fenwick West, which is a storied law firm in the area here. I think I mentioned when I introduced him last time, but I'll mention again that Fenwick West was incorporated Apple in 1976, negotiated one of the first licensing agreements with a young Bill Gates, took companies like Oracle and eBay public, defended Amazon's one-click patent, a number of things. So a lot of the interesting IT legal issues, and really an incredible part of the Silicon Valley and IT ecosystem. So Zach works at Fenwick, where he advises on a variety of IP matters with a focus on technology, as I said, IP, privacy, and particularly related to AI, machine learning, and digital health. Also counsels clients on commercial contracts, open source aspects of venture financings, mergers and acquisitions. Prior to his career in the law, Zach was a mental health professional who served combat veterans with PTSD at the VA. He's a graduate of Stanford Law School and an AIMI Associate Fellow. As I said, he's been here before to talk to us about the FDA and AI machine learning medical devices. Today, he's back to talk to us about another key regulatory issue in our work, and that's HIPAA, medical AI, and privacy. Zach, we're delighted to have you here. Thanks for being here. Take it away.
Wonderful. Thanks. Thanks so much. Hi, everyone. I'll go ahead and share my screen. Okay. So yeah, delighted to be here. Thanks, Amy, for inviting me to be here and give this talk on a topic near and dear to my heart. The goal for today is going to be to first understand what HIPAA is and how it works, and then to explore what implications that has for our use of medical AI. I was going to do a slide about who I am, but Kurt did such a wonderful job introducing me. It would pale by comparison, so I feel like you guys know me already. And yeah, happy to sort of dive into these fun and interesting questions. So first, what we'll do is we'll just get to know HIPAA a little bit better. So I want to get a handle on what the laws are that are at play here. Privacy law in the US is siloed, unlike, for instance, in the EU, where there's an omnibus privacy law, namely GDPR. Here in the US, we have different laws for financial privacy, for education privacy, and of course, for health privacy. But when you think HIPAA, you usually think privacy, so you might be surprised to learn that the P in HIPAA actually doesn't stand for privacy, but portability. Nevertheless, privacy is certainly an important part of HIPAA, as we're going to see later when we dive into the privacy rule components of the law. I should also mention the HITECH Act, which was enacted in 2009 to expand upon HIPAA and promote the adoption of health information technology and electronic health records, and provide funding for implementation of those initiatives. The HITECH Act strengthens HIPAA's privacy and security rules and includes new notification requirements for data breaches, as well as increased penalties for non-compliance. I should also note that there's various state-specific laws that regulate the disclosure of health information or medical records, but I'm going to be eliding over that today and simply focusing on HIPAA during this presentation. The Department of Health and Human Services, or HHS, is a cabinet-level department, and it is the one that's responsible, for the most part, for HIPAA and the HITECH Act. To the right, you can see the official HHS org chart. I know what you're thinking. Zach, why did you use such a blurry screen grab here for this org chart? You know, I was really looking forward to examining this in detail later when the video gets posted. Now I'm going to have to squint. Well, the truth is this chart is actually this fuzzy on the HHS website. but they insist on continuing to use it. They now offer a somehow worse text version of the chart, so we're stuck with this one, and I'll just highlight the relevant parts and we'll forge on. First, I want to highlight the Office of Civil Rights, or OCR. This is the one that's responsible for enforcing HIPAA and the associated penalties, which we'll get to shortly. Next is the Office of the National Coordinator, or ONC, which is responsible for enforcing the HITECH Act. And at the end of February, HHS noted that it will be creating new divisions in OCR and performing some reorg in order to better facilitate the growing enforcement caseload. Also note that the HITECH Act allows for state attorney generals to sue for unauthorized use or disclosure of PHI of their particular state residents. So that's one more potential enforcer that could be thrown into the mix here. So as everybody knows, HIPAA involves PHI, whatever that is. Well, buckle up because we've got a real ugly slide here. But in performing a HIPAA analysis, you always want to first make sure that HIPAA actually applies to you. And if you're not dealing with PHI, then you likely don't need to worry about HIPAA. But that means we want to be really clear about what PHI actually is. So you might have some trouble focusing on what the slide is saying, because all you can think about is the fact that I've clearly made some grievous error since the title says PHI, but the slide is going on at great lengths about defining individually identifiable health information. Well, what's going on there? That's just because the heart of the definition of PHI is this core concept. The real definition for PHI just says that it is individually identifiable health information that happens to be transmitted or maintained in electronic media or any other form or medium. So with that settled, let's dig into what the definition actually says. So PHI basically is information that's going to relate to the individual's past, present, or future physical or mental health condition, or the provision of healthcare to the individual, or the past, present, or future payment for the provision of healthcare to the individual. And it has to be the case that that information identifies, or there's like a reasonable basis to believe that it could identify the individual in question. With HIPAA, it's always important to find out whether that law is going to apply to you. And in addition to figuring out whether you're dealing with PHI, you also want to figure out whether the PHI is being handled by a covered entity or a business associate, whatever those are, because those are the only things that HIPAA applies to. If HIPAA ends up not applying to you, then you avoid a lot of overhead and compliance work that needs to be done. So that's part of why this analysis is so important. So this chart on the right is from the HHS website, and it details the three types of covered entity, namely healthcare providers, health plans, or payors, and then finally healthcare clearinghouses. In addition to covered entities, there's business associates. Those are entities that are using, disclosing, or processing PHI on behalf of a covered entity. So basically, if you have an AI model and you're looking to use some PHI for model training, and you're not a covered entity, then you're likely going to be a business associate. This matters because business associates have to enter into things called business associate agreements, or BAAs, which we'll discuss in more detail later. Now, the main part of HIPAA that we're going to be focusing on today is the privacy rule, which is complicated and convoluted and long. But I'm going to give you a quick one-slide crash course on what the highlights are. So HHS tells us that the basic idea is that if you're a covered entity or a business associate, you're not permitted to use or disclose a patient's PHI unless either you have the patient's authorization in writing or unless it's otherwise permitted by the privacy rule. Okay, great. What else is permitted by the privacy rule? Well, there's a bunch of different things. But we're going to be focusing on the TPO permissible use today, which stands for treatment, payment, and healthcare operations. Basically, this means that if you're a covered entity or business associate and you're using or disclosing PHI, you can do so without obtaining the patient's authorization, provided that the disclosure involves you providing treatment to the patient or involves you processing payment related to the patient, or it's involved in your healthcare operations. We're also going to discuss how research activities can qualify as permitted disclosures, along with covering what a limited data set is and how it relates to research activities. We're going to dive into each of these scenarios in more detail later in the context of AI, so there's no need for us to get into the nitty-gritty now. I just want to give you a broad lay of the land for the privacy rule, and I think I'm going to say mission accomplished. One last thing to mention, you might be wondering, like, why is it such a big deal to have to get a patient's authorization? Like, can't you just have them check a box or something similarly low friction? Unfortunately, no. When it comes to patient authorization, voluntary consent alone is insufficient to permit a use or disclosure of the PHI. What's needed is a valid authorization, which is a detailed document with specific requirements in which voluntary consent is only, one element. So naturally, it's desirable to avoid that administrative burden if possible. I think it's important to also give a quick overview of another important facet of HIPAA, which is the security rule. However, I'll note that when we get to the AI part of the talk, as I'm sure many of you are already wondering if that's ever going to happen, we'll focus largely on the privacy aspects, but it's still good to be aware of the security side of things. In essence, the security rule states that you must protect the PHI you possess and be proactive in defending against possible unauthorized disclosures or uses. You also have to make sure that your workforce understands the risks and is implementing the necessary measures, which are various administrative, physical, and technical safeguards. Finally, the security rule requires the covered entity or business associate to balance and consider various factors in determining its security measures. These include its size, complexity, and capabilities, its technical hardware and software, infrastructure, the cost of imposing such security measures, and the likelihood and possible impact of potential risks to the patient PHI in question. Okay, now that we're duly familiarized with HIPAA, we can turn our attention to some scenarios investigating medical AI as it specifically relates to the statute. We'll look at two primary pathways to consider regarding processing of PHI by an AI system, and we'll keep an eye toward identifying any applicable carve-outs or safe harbors that could protect an organization's AI-related activity. So if you find yourself in the position where you want to use some PHI to train an AI model, these are the two main approaches, and they each have very different consequences. Firstly is the de-identification approach. If this approach works for you and your data needs, this is a great approach and it's going to mitigate a lot of risks. HIPAA essentially provides a safe harbor for de-identification of PHI, where if you satisfy the requirements, then HIPAA no longer applies to that de-identified data. That is, you can use it for whatever you want, train your model, sell the de-identified data, donate it to a data pool, etc. You get lots of freedom with this approach because the data is not actually PHI anymore, and that means that HIPAA doesn't apply to it. There's three main downsides to this approach. First is you have to find a way to de-identify the data in the first place. Secondly, you then have to make sure you actually de-identified the data, which we're going to talk about more shortly later. And thirdly, the de-identified data has elements stripped out of it by necessity, which means that the de-identified data could have removed signal that training your AI, your medical AI model might need. But if you can handle those three things, then you're in the clear, making this a very desirable approach to pursue. The second approach is finding a permitted disclosure in treatment, payment, or healthcare operations, or TPO. I also added the R there for research, which we'll discuss in more detail a bit later. You might forget most of what I talk about today, but if you remember this slide, you're going to be in a pretty good position. This is a great takeaway slide, and part of the reason for that it's so great is that you don't even have to fully understand it to still be in a good spot. For instance, you might only remember that you should try to de-identify the PHI. And if you can't do that, then you have to do something else. You forget what it's called. Or maybe you remember it's called TPO, but you have no idea what that is. But you at least know that there's something you have to do. And now you know to call up your lawyer and figure out what your plan of attack is. This is going to take you a long way in terms of staying out of trouble. It's still worthwhile to go deeper into these issues to better understand what they are and what they involve and what's at stake. So we're going to start with branch 1, the de-identification safe harbor. Okay, so I already talked up all the great points for taking branch 1. So how do we actually take advantage of this safe harbor? Well, there's 2 ways to satisfy the de-identification safe harbor. The first one is called the expert determination method, in which a covered entity or business associate obtains a written determination from an appropriate statistical expert that the risk of identification of an individual is very small. Now, like in this cartoon, we've all had to call in an expert from time to time, but this safe harbor involves some fuzzy details, such as who's considered an appropriate statistical expert and what it means for a risk of identification to be, quote unquote, very small. The much more popular safe harbor pathway is the identifier removal method, in which the covered entity or business associate removes 18 categories of identifiers. For example, your name, phone number, email, social, medical record number, device identifier, IP address, biometric identifiers, etc. And it also has to be the case that the covered entity does not have actual knowledge that the remaining information can identify the individual in question. Although the identifier removal method provides the clearest path to the safe harbor, it may be difficult to achieve in practice. So for example, for unstructured data, it may be challenging to verify that all 18 identifiers have been successfully removed. A practical point here is that if you're the entity with the AI model hoping to use this de-identified data, you likely need specific language in your business associate agreement that grants you permission to de-identify the data. But we're going to discuss that in more detail later when we get to healthcare operations. The de-identification safe harbor sounds great. After you've gone through the job of de-identifying the data, you can freely use that data to train your AI model without having to worry about HIPAA. You can also take advantage of the fact that many other people have taken pains to de-identify valuable PHI and then packaged it up in a shareable data set for you to access and use. A great example of this comes from the Raj Prakar lab at Harvard. Pranav gave a great talk here at AIMI a few months ago, which if you haven't seen yet, I definitely recommend going back and watching. His lab is also responsible for the MEDA initiative, which stands for Medical AI Data for All, in which they've pooled large swaths of de-identified medical data from across the globe to be shared to accelerate medical AI progress. So de-identification sounds promising, but of course, the devil is always in the details. And in this case, those details mean actually making sure that your data is really de-identified to the standards set by HHS. After all, people mess up with this sort of thing all the time. And when it comes to combing through all your data to make sure that you scrubbed out all 18 identifiers, it's just like Pokemon, and that you've got to catch them all. If some identifiers slip through the cracks, then all of a sudden you've just learned that the de-identified data you thought you were freely using is actually PHI you were likely using in violation of HIPAA, which means it's probably a good time to call your lawyer. Although exaggerated for comedic effect in this cartoon, you do have to be mindful that you don't scrub out too much in the de-identification process. Depending on your AI model and its use case, it's possible that valuable signal is being lost in removing the 18 identifiers. So as we noted before, de-identification is not necessarily a one-size-fits-all strategy. Now, because you're all savvy to the world of AI, you know that even though you may be using de-identified data, there have been some studies showing how such data or similar data could potentially be re-identified using various methods or attacks. So one of your first thoughts may be, does this ruin that de-identification safe harbor for me? Because I now have, quote, actual knowledge that the data can be used to identify an individual. So great question. HHS has read your mind on this because in their FAQ, they address this very issue. The good news is that they say you can be aware of such studies about methods for re-identifying information, but this in itself doesn't mean that you have actual knowledge that such methods would be used on the data you're using or disclosing. They go on to note that you're not required to presume such capacities of all potential recipients, since that would essentially defeat the purpose of the safe harbor method. However, if you know that the recipient does have such capabilities, and has used those capabilities in the past, then you're probably in actual knowledge territory, and the safe harbor may not apply to you in that case. So this wraps up our exploration of branch 1, the de-identification approach. Now let's turn our attention to branch 2 as it relates to the use of PHI for AI activities. This covers TPO, which again stands for treatment, payment, and healthcare operations. And again, I've added the R here for research, which we'll discuss in a bit. So if no safe harbor applies, then recall a covered entity or business associate is prohibited from using or disclosing PHI unless there's a specific permission granted by HIPAA, such as treatment, payment, healthcare operations, or research. In those cases, no authorization or consent is required to be obtained from the patient whose PHI is being processed by the medical AI model. Sadly, the Far Side comics have a lot of treatment-related examples, but apparently medical payments and healthcare operations and medical research are not rich depths of comedic material, so you're stuck with these boring stock graphics. But not for long, because next we're going to dive into each of these 3 areas in turn and further examine how they apply to the use of medical AI models. I'll say here at the outset that HIPAA is a very complex statute, and I'm largely giving a broad overview, so there are certainly many caveats and exceptions to lots of the points I'm going to cover here. So let's say you're either a medical AI developer who's built a tool that can be used to assist in patient treatment, or you're a physician that wants to use such a tool. If you want to avoid getting a formal HIPAA authorization from each patient using the AI tool, you'll need to satisfy the treatment exemption. So what does that involve? Firstly, an activity is considered treatment only if it's delivered by a healthcare provider or a healthcare provider working with another party. Secondly, treatment must be on behalf of a single patient, not a population. HHS clarifies, noting that although population-wide analysis or intervention may prompt a healthcare provider to offer specific treatment to an individual, those population-based analyses would still not constitute treatment. Those would instead be, they would fall under healthcare operations, which we're going to discuss later. This narrow focus on single patients puts this permitted disclosure outside the scope of most AI developers who are going to be focused on training their models to help a population of patients. Excuse me. However, there might be scenarios related to personalized medicine in which this permitted disclosure could come into play. Finally, as we've noted before, you're likely going to need to enter into a business associate agreement. This is an agreement that governs the sharing of data between a covered entity and the business associate, or covers the sharing of data between a business associate and their own subcontractors. We're going to breeze through payment fairly quickly because the analysis is relatively straightforward. This is a shame because the example I'm going to use involves everyone's favorite topic, CPT codes. And here's a quick sampling of a few of my favorites. We're going to consider the case of a hospital where the hospital is the covered entity. It contracts with an AI vendor, the business associate, perhaps to find money left on the table due to inaccurate CPT codes being used. So long as there's a business associate agreement in place, then this processing of PHI by the AI model is permissible and does not require patient authorization. Similarly, it might be that a health insurance plan wants to use an AI vendor for similar billing review, in which case the same analysis applies. It's just that the covered entity is now the health insurance plan instead of the hospital. So next, I suppose then the two AIs are going to duke it out with each other over the CPT codes. But the headline here is that the AI processing of the PHI is permissible with a business associate agreement in place. Let's return to our scenario with the medical AI developer and the physician wanting to use the AI tool. The healthcare operations definition in HIPAA is quite broad, and it's going to include things like conducting quality assessments and improvement activities, as well as business management, general administrative activities. As you might remember from earlier when we discussed how treatment must be individual focused, in contradistinction to that, healthcare operations include population-based activities, such as those related to improving health or reducing healthcare costs. However, the medical AI developer needs to be mindful that the application of AI to the healthcare operations of a covered entity must be at least in part for the benefit of the covered entity. There's not great clarity from HHS on how far exactly this extends. So for instance, if data aggregation is permitted under the BAA, then the business associate can combine PHI from one covered entity with that of another covered entity to permit data analysis that relate to the healthcare operations of the two covered entities in question. But does that mean you can train your AI model on the PHI from multiple covered entities and consider that data aggregation? Although HHS has not weighed in on this issue explicitly, their commentary suggests that this is not what the data aggregation exception was intended for. Additionally, HHS has suggested that the data mining for the business associate's own purposes is not permitted under HIPAA. That means the conservative understanding here would be that if the AI vendor trains its AI model using a covered entity's PHI under this healthcare operations permitted use, then that model would need to be firewalled for use only with that particular covered entity. So as you can see, there's certainly lots of gray area here. Again, one of the reasons why working with de-identified data is often preferable. Speaking of such, way back when I showed you the two branching approaches slide, I'm sure some of you were thinking, sure, de-identification sounds good, but how do you actually get your mitts on that de-identified data? The covered entity probably isn't going to want to do it for you, which means you're going to have to de-identify it yourself, which means you're going to need the rights to access that PHI via some permitted disclosure, but which one? Well, if you've been quietly sitting on that question, your time has finally come. One of the most noteworthy items in the definition of healthcare operations is the use of PHI to create de-identified data. And once de-identified, that data can be used for the business associate's own purposes. For instance, the data could be de-identified and then sold, or used to train the AI vendor's medical AI model for commercial purposes. However, the de-identification itself still needs to be permitted under the BAA, and it must also be done on behalf of the covered entity. So best practice the safest route here would be to have a specific purpose for de-identifying that data that benefits the covered entity, providing you with the PHI in the first place. Hence, if you're a medical AI developer, this is likely something important to push to include in your business associate agreement, because as we noted before, once you have that de-identified data, HIPAA no longer applies to it, and you can use it freely. Finally, we come to one other permissible disclosure that I only briefly mentioned before, namely research. This is defined as a systematic investigation, including research development, testing, and evaluation designed to develop or contribute to generalizable knowledge. Although there's some gray area on the issue of what constitutes research, one item for medical AI developers to note is that HHS appears to think research can be commercial in nature in some circumstances, rather than just academic. This is because they note that PHI could be disclosed to a pharmaceutical company for quote unquote research purposes. So you might be thinking, perhaps aided by the title of this slide, that there seemed to be some overlap between the definition of research and that of healthcare operations, at least in the case of improving and assessing healthcare quality. You would be right, and HHS acknowledges this by saying that the distinction between healthcare operations and research rests on whether the primary purpose of the study is to produce generalizable knowledge. So now you might be thinking, who cares? Well, since I'm talking about it in this presentation, you can safely assume that lawyers care about it. But of course, you still want to know who else. I mean, after all, lawyers care about all sorts of inane things. Basically, you should care about it because, as you recall from the last slide, we noted that if you use PHI from a covered entity to train your AI model via that healthcare operations permitted disclosure, you likely can only use that model for the specific covered entity you got the PHI from. But because the research permitted use is about generalizable knowledge, it's better suited to allow you to train your AI model for use with entities other than the covered entity you got your PHI from. But this additional freedom doesn't come without strings. So recall that if the PHI is shared as a healthcare operation, then a business associate agreement is required between the covered entity and the medical AI developers. But if the PHI is shared under research, then different requirements apply. For example, you might need to get patient authorizations, which, as you recall, is a formal document that introduces friction into the data acquisition process. Or you'll have to get an IRB waiver of that specific requirement. If neither of those two options obtain, then you'd need to enter into a data use agreement with the covered entity, wherein you're granted access to something called a limited data set. So a limited data set is basically PHI that's had almost all of the 18 identifiers we saw earlier stripped out, but the limited data set can still include the town, city, state of the individual, their gender, dates related to the individual, or any other unique identifier that's not enumerated in the list of 18 identifiers. Now, HHS, of course, recognizes that things are fluid and states that if the activity transitions between healthcare operations to research or vice versa, it just needs to be documented, and then compliance with the new requirements needs to be observed. So summing up, there may be some additional freedom that comes from using PHI under the research permitted disclosure, although it's not completely clear whether the AI vendor could use that research PHI for commercial purposes. And this freedom may come at the cost of additional compliance obligations that the healthcare operations permitted use isn't subject to. So your big takeaway should be, if possible, follow branch 1. It's much simpler, it's more permissive and clearer regarding what you can and can't do with that data. Now, I do want to note here, these aren't the only two paths available. As we noted before, you could also attempt to obtain patient authorization from every individual whose PHI you intend to use to train on your AI model. Depending on the platform and onboarding process you currently have set up and the number of patient authorizations you need for your data set, it is possible to cleverly design this process to minimize friction and gather the necessary PHI. So again, just wanted to point out, nothing is one size fits all when it comes to HIPAA. As we've seen, HIPAA states that you can't use or disclose PHI unless you satisfy one of the permitted uses, for example, treatment, payment, healthcare operations, or research. But what if the AI model's processing of PHI isn't even a use or disclosure in the first place? Then HIPAA wouldn't apply. If you're a medical AI researcher, this might sound pretty exciting. You might feel even more excited when you hear that in a privacy rule commentary issued by HHS, it states that quote unquote computer processing of data does not constitute a quote unquote use, which would appear to open the door to a colorable argument that eyes-off model training on PHI would not be a use of PHI and hence not be subject to HIPAA. But don't get too excited. Firstly, that privacy rule commentary is guidance, and thus it's non-binding. Also, it was issued back in the year 2000, so HHS may think differently about the issue in the subsequent 20+ years of rapid technological development we've seen since then. Remember, they were just worried about Y2K back then, as were we all, but that gives you a feel for how the times have changed. Secondly, the example from the commentary involved computer processing regarding search queries, which could be distinguished from the more sophisticated and transformative computer processing involved with model training, which arguably involves some level of data learning or even memorization, which has been revealed in overfitting models or certain model inversion attacks. And thirdly, OCR published a fact sheet on ransomware in 2019, which stated that the computer processing of ransomware, accessing and encrypting data constitutes a use. So if eyes-off malware encryption is a use, then it could similarly be argued that eyes-off model training on PHI is also a use. Okay, so although there's perhaps an interesting argument that could be made here, it's likely not solid enough to be relied on. For that reason, it makes more sense to rely on one of the two pathways identified earlier, namely either de-identification of the data or one of the TPO and R permitted disclosures. Another important requirement of HIPAA is the so-called minimum necessary standard, which says a covered entity or business associate must make reasonable efforts to use or disclose only the minimum necessary amount of PHI to accomplish its intended purpose. If you're an AI researcher, you probably cringe just hearing the words minimum necessary. We know big AI loves big data and is never full. It always wants more. This is just an observation of an inherent tension between one of the HIPAA requirements, namely the minimum necessary standard, and one of the fundamental aspects of AI, namely its insatiable hunger for data. Now, of course, that's not strictly accurate, and there's definitely movements in AI focusing on smaller, better, cleaner data, including the data-centric AI focus promulgated by Stanford's own Andrew Ng. So in some ways, this tension is maybe not as strong as initially imagined. But it's still a useful principle to keep in mind, and there may be some relatively easy steps that can be taken for compliance. For example, the AI model might not need to know the patient's names and social security numbers, so simply swapping them out with a unique identifier helps satisfy the minimum necessary standard. Additionally, when dealing with tabular data, there might simply be a number of columns that are not reasonably necessary for your AI model. So proactively removing them, again, is going to further help compliance with this particular requirement. Now, I've been focusing on the legal side of things, but there are, of course, various technological methods that can be used as well to help mitigate health privacy risks. This includes federated learning, as we've seen in this recent very large study in Nature, as well as various other similar distributed AI techniques. Since it's impossible to get through an AI presentation these days without uttering the words generative AI, I would be remiss to not mention the potential advantages of synthetic data. There's myriad examples, including this recent work by Google on developing synthetic EHR records, as well as this recent paper by JAMA showing equivalent or near equivalent performance of a glaucoma detection model trained on purely synthetic data versus a model trained on purely real-world data. Now, use of synthetic data could be helpful for a scenario in which de-identified data won't suffice, but you're unable to access PHI from a covered entity, either because no TPO and R permitted disclosure applies, or because you can't obtain the necessary patient authorizations. Now, this JAMA paper here involved using boring old GANs, but obviously we all know latent diffusion is the rage these days. So I, of course, need to mention this paper with the very cool idea of using and fine-tuning stable diffusion to generate chest x-rays. Clearly, there were some very brilliant minds at work behind this paper. Synthetic data introduces all sorts of interesting possibilities for the medical AI vendor, since it could provide the ability to train on PHI-esque data that's not actually PHI. However, the crucial issue, at least from the privacy perspective, will be to ensure that the synthetic data is in fact truly synthetic and it doesn't contain any PHI. So what happens if you run afoul of HIPAA? This is called a breach, which is an impermissible use or disclosure that compromises the security or privacy of PHI. Breaches come with notice obligations, financial penalties, even the potential for criminal penalties. These criminal penalties are for knowing violations of HIPAA, and they're tiered, with the most severe tier bringing in fines as well as up to 10 years of jail time. This is for obtaining PHI for personal gain or for malicious intent. This is what I like to think of as the why do I care slide. Activity in this space is obviously evolving, and you might see lots of non-compliance out there, but penalties for that non-compliance can be hefty if you're caught. So note that these penalties, they're inflation adjusted. These are the 2022 figures. We're still waiting for HHS to officially update the numbers for 2023, but the multiplier will be an increase of around 8%. On the slide, you can also see the running fines and settlements from 2023, and the one for Banner Health is a doozy. If you were to look back to 2021, you'd also find a settlement for a whopping $5.1 million. This is just a quick example noting that HIPAA is not the only game in town when it comes to privacy. So for example, there's the California privacy laws, CCPA and CIPRA. CIPRA notes that HIPAA preempts it. So that means if you're dealing with PHI and HIPAA is implicated, then you don't have to worry about also complying with CCPA and CIPRA. But we're not out of the woods just yet. There's an amendment to the CCPA stating that transactions for the sale of de-identified data must include provisions prohibiting the re-identification of such data. So firstly, it's important to note that sale is construed very broadly and could include cases in which the data is being shared without monetary compensation. And secondly, I should note that this amendment has a really long arm. Typically, CCPA only applies to California entities that meet specific thresholds, for example, having over $25 million in annual revenue. But this amendment can apply to non-California entities or California-based entities that don't meet those specific thresholds. Now, there's other health data specific laws and regulations that are broader in that they cover organizations that would not be classified as covered entities or business associates. For example, the FTC has revitalized its health breach notification rule. This rule was issued over 10 years ago, but was not really enforced until now. You may have read about this law recently in the headlines, where FTC announced its first enforcement action under this law, imposing a $1.5 million fine. And in March, bringing an enforcement action against BetterHelp with a consent order requiring payment of $7.8 million. Now, if you're in need of some practical advice on what to consider and how to comply with this FTC rule, you're in luck. Fenwick just put out a great summary article on the topic, so feel free to check it out. And there's lots more of these. So for instance, CFR Part 2 governs federally assisted substance use disorder treatment programs and disclosure obligations around that related to confidentiality. Also, states often have specific privacy laws governing health data and medical records, and those in many cases can be more stringent than HIPAA. Finally, I've been going through at pains many of the legal considerations and consequences of HIPAA compliance for medical AI, but I should of course note that there are other non-legal considerations as well. So for instance, certain activities might fully comply with HIPAA, but if the public deems them to be irresponsible or lacking in transparency, that could lead to reputational risk. There's certainly examples of this phenomenon playing out, and once the damage is done, championing your own compliance with the letter of the law can ring a bit hollow. Staying out of ethical trouble can also minimize regulatory scrutiny, where such scrutiny can not only be expensive monetarily, but also involve bad press and lead to management distraction. This concept includes avoiding regulators who are already patrolling the field looking for misdeeds. It also includes not inviting further interest or investigation from other regulators. So for instance, in August of 2022, the California Attorney General sent a number of letters to hospital CEOs inquiring about their use of medical AI tools for potential bias. This was likely motivated by various stories that had been catching the headlines recently regarding racial bias concerns associated with medical AI. This also means that unfortunately your competitors' missteps could bring down regulation on your head. So your best protection for that is just going to be to try and keep your own nose clean. Okay, and with that, I'll thank everyone for your attention. And why don't we go ahead and open it up for any questions?